A preliminary hearing is just me going against the state's evidence. The state will put up whatever evidence they have just to demonstrate probable cause. The standard in the General Sessions Court is not the beyond a reasonable doubt standard of the criminal court. In General Sessions Court, it's just probable cause. Is it more likely, just barely more likely than not, that there's enough evidence for you to be charged with a DUI? So they don't have to prove the DUI completely. They just have to prove that there's enough evidence to arrest you for a DUI. Proving it beyond a reasonable doubt is for later, either at a bench trial in the criminal court or in front of a jury. And so the way to get it dismissed in the General Sessions Court is to make every argument, first of all, that it was a bad stop, that it was unconstitutional because you were illegally seized by an officer who didn't have a reasonable suspicion that any crime was taking place. Then to show that after that, there wasn't a good reason to get you out of the vehicle, that they didn't have probable cause for the arrest before the field sobriety test, and then the field sobriety test did not elevate their suspicion to a level of probable cause. And if I can show that, or if I can make enough of an argument to get maybe the breath or the blood suppressed, and so the state won't be able to use that as evidence against you at that hearing. I've been successful in many cases of getting DUIs dismissed at a preliminary hearing. Here's the bad news. The DA can still take that charge to a grand jury, and they can still resurrect this case in the criminal court, even if I get it dismissed in the Sessions Court. So the bottom line of the Sessions Court is really that's the opportunity to get cases settled before they go to the criminal court. That's why the cases stay there what seems like a long time, but the reason they stay there so long is because I want every opportunity. I want to continue the case as long as I can because I want to take every opportunity to convince the DA that this is not a case that can be won at trial and get them to offer something other than just plead to the DUI and take the punishment, whatever that is. And in most cases, it's DUI minimums.